Have you ever really thought about what's in a name? Well, it turns out, in the world of medicine, just a few letters on a box can be worth millions, and they can spark a legal war that lasts for a quarter of a century. Today, we're diving into the incredible story of one company's 25-year fight to protect its brand, all boiling down to the 6-letter suffix "continuen."
Okay, so let's just look at what we're talking about here. On the left, you've got FEMICONTIN-F. On the right, FEMICONTIN. I mean, you can see the issue right away, can't you? The names sound almost identical. The packaging has that same orange and white vibe, and they're both aimed at the exact same customer.
And that's really the heart of the matter. This is the big question the High Court of Delhi had to answer. Are these names and packages deceptively similar? Is FEMICONTIN stepping on the toes of the FEMICONTIN-F trademark? This one question is the core of the entire legal fight.
Now, to get why this fight was such a big deal, you have to understand what was on the line for Modi-Mundipharma. This was never just about two products sitting next to each other on a pharmacy shelf. Nope, this was about defending an entire empire they had built on a single 6-letter word.
See, they didn't just argue that FEMICONTIN sounds a lot like FECONTIN-F. Their claim was much, much bigger than that. Think of it this way. This wasn't just about someone copying one specific McDonald's burger. It was about someone else starting to use that Mick prefix on their own food. Modi-Mundipharma was basically saying the defendant was trespassing on their entire brand family's turf.
And this is where a really interesting legal idea comes into play, the family of marks. The concept is pretty simple, actually. If a company uses a common element, a prefix, or in this case a suffix, across a whole bunch of its products, that little element itself becomes a trademark. When you see it, you don't just see a product, you see the company behind it. And this table just drives that point home perfectly. Look at this. Modi-Mundipharma wasn't just pulling names out of a hat. They had a very deliberate long-term strategy. They registered over 30 names, all ending in continuen, from morcontin to dilcontinuen. They were teaching the public that when you see continuen on a medicine box, you think of them. It was their signature.
And look, this wasn't just about some abstract legal principle. This was about money, a lot of it. Just one single product from this family, FECONTIN-F, pulled in over 13 crore rupees in about a decade. So yeah, the financial stakes here were incredibly high. All right, so you've got this valuable brand empire built on a single suffix. How does that turn into one of the longest, most drawn-out legal battles the industry has ever seen? Let's walk through the timeline. It's a real story of persistence, legal chess, and a whole lot of waiting.
So this was anything but a quick fight. It was a true legal marathon. It all kicked off way back in 1999 with a simple cease and desist letter. Then came a lawsuit in 2002, which got withdrawn. Then a new one in 2005, also withdrawn. The case that finally stuck was filed in 2007. And get this, it wasn't until 2023, 16 years later, that a judge finally dismissed it, which then triggered one last appeal. We are talking about a 25-year journey through the court system.
So after all that time, all those twists and turns, the case lands in front of a final bench at the Delhi High Court in 2024. Now it's their job to sift through literally decades of arguments. So let's break down how they tackled this incredibly messy problem.
The judges basically had to answer a few key questions. First, did the company wait too long to sue? Second, was their CONTIN family of marks really infringed upon? And then there was this issue of passing off, which is really just a fancy legal term for asking if one company is trying to trick customers into thinking their product is connected to another, more famous one.
The court didn't just look at the names, though. They looked at the actual products. And you can see, while they're not identical, they're pretty darn similar. Both are basically iron and vitamin supplements with folic acid. The court pointed out that they were sold to the same people through the same stores, and that's a huge factor when you're worried about customer confusion.
So the plaintiff's case was pretty straightforward. They argued that FEMICONTIN was a clear infringement on their brand. But what did the other side have to say? Well, their argument was that continent is just a descriptive word, probably from continuous release, and you can't just monopolize a common term like that. They claimed their prefix, femi, was different enough from phi to prevent any mix-ups.
And this is where things get a little weird. The judges noticed something they called a puzzling feature. Both legal teams spent years arguing as if these were Scheduled H drugs, the kind you need a prescription for. But the court looked at the boxes and pointed out that neither product actually said that. It was this bizarre factual error that both sides just rolled with for decades. You have to wonder how something like that even happened.
So here we are, July 1st, 2024. The High Court has to weigh everything: the family of marks argument, the descriptive word defense, the similar packaging, and those 2.5 decades of legal battles. They had to make the final call. Would they agree with the earlier dismissal, or would this 25-year fight finally pay off for the plaintiff?
Okay, so you might be thinking, a 25-year fight over 6 letters, why should we care? Well, this case matters because it pulls back the curtain on the invisible battles that are constantly being fought over brand protection, consumer safety, and the super high-stakes world of pharmaceuticals, a world that affects all of us.
And this really gets to the heart of it. Protecting a trademark on a medicine isn't just a business squabble. It's a public safety issue. If people get confused between 2 different drugs, even ones with similar ingredients, there can be very real consequences. The law is there to stop that from happening.
This whole saga leaves us with this huge question. In the fight for our attention, where does the law draw that line between being inspired by a competitor and just straight up imitating them? In this case, the High Court finally sided with Modi-Mundipharma. They ruled that FEMICONTIN was in fact an infringement. They backed up the power of a family of marks, setting a major precedent. It's a powerful reminder that in the world of branding, a few letters can be the foundation of an empire, and defending them can become the fight of a lifetime.